Over the past day, a convergence of events has pushed this legal and political situation into territory that experts are treating with unusual seriousness. Public statements from Donald Trump, a rare procedural move by a federal judge, and visible security preparations in Washington are being evaluated together rather than separately. That combination is what has elevated concern, not any single action on its own. It begins with language. In recent statements posted publicly, Trump used rhetoric that referenced civil conflict, force, and resistance if legal and congressional actions continue against him. The wording stopped short of an explicit call for violence, but it was forceful enough that multiple legal analysts and former officials described it as crossing into dangerous territory. In the current climate, especially given recent history, such language is not treated as abstract political speech. It is assessed for potential real-world impact. Security agencies evaluate words differently than political commentators do. They look at patterns, timing, audience reaction, and precedent. When rhetoric references conflict or armed resistance, it triggers review mechanisms regardless of whether the speaker claims metaphor or exaggeration. That review does not mean violence is imminent, but it does mean risk must be assessed. At nearly the same time these statements circulated, a federal judge overseeing a Trump-related matter took a step that significantly raised the institutional stakes. The judge formally referred findings to Congress, signaling that the court believes judicial remedies alone may be insufficient to address the conduct at issue. This type of referral is rare and carries constitutional weight. It does not itself remove anyone from office, nor does it automatically trigger impeachment, but it places responsibility squarely on the legislative branch to determine whether further action is warranted. Judges are acutely aware of separation of powers. Courts do not lightly invite congressional involvement. When a judge makes such a referral, it usually reflects a conclusion that the issues involved extend beyond ordinary litigation and into questions that only Congress has the authority to resolve. Legal scholars immediately noted that this move suggests the court has exhausted or nearly exhausted its procedural tools. As news of the referral spread, attention quickly turned to Washington, where security posture became visibly more pronounced. National Guard units were placed on heightened readiness, and in some areas were deployed in a precautionary role. Officials emphasized that these measures are preventative rather than reactive. There has been no declaration of martial law. Civil authority remains fully intact. Government functions continue as normal. This distinction is critical. The presence of National Guard units does not automatically signal an emergency or an expectation of violence. It signals preparedness. After January 6th, security agencies changed how they respond to rhetoric that could mobilize large groups. The priority now is deterrence and readiness, rather than waiting to see if threats materialize. What has alarmed observers is not that any single institution acted, but that several did so simultaneously. Trump's rhetoric, the judge's referral, and security preparations are being interpreted as interconnected responses to a volatile moment. When courts escalate procedurally and security agencies adjust posture at the same time, it indicates concern about maintaining order during a period of heightened tension. It is important to be precise about what is happening and what is not. There has been no confirmed impeachment vote at this moment. Congress has not yet acted on the referral. No court has ordered Trump's arrest in relation to these statements. Claims circulating online that the country is under martial law are false. At the same time, dismissing the situation as routine would also be inaccurate. Judicial referrals of this nature are uncommon. Security adjustments of this visibility are not made casually. Institutions are responding proactively because they are attempting to prevent escalation rather than react to it after the fact. From a legal perspective, the referral places Congress in a position where inaction itself becomes a choice. Lawmakers must now decide whether to open formal proceedings, request further information, or decline to act. Each option carries political and constitutional consequences. That deliberation will unfold under intense public scrutiny. Trump's statements are also being evaluated through multiple legal lenses. While political speech is protected, there are limits when speech veers into intimidation, obstruction, or incitement. Determining whether any threshold has been crossed is a fact-specific analysis that depends on context, intent, and effect. Investigators do not rely on headlines or social media reactions. They rely on evidence, timelines, and expert assessment. For Trump's legal team, this moment represents a compounding challenge. Legal exposure is no longer confined to filings and hearings. Public statements are now part of the risk matrix. Every word is scrutinized not only for political impact, but for how it may be interpreted by courts, lawmakers, and security agencies. There is also a broader institutional concern at play. Courts, Congress, and security forces are designed to operate independently, but in moments of national stress, their actions inevitably intersect. When those intersections become visible, it reflects a system attempting to stabilize itself under pressure. Analysts emphasize that this does not mean collapse is imminent. It means safeguards are being activated. The purpose of judicial referrals, legislative review, and security preparedness is to ensure that disputes are resolved through process rather than force. The language used by Trump has intensified this dynamic. Even if supporters view it as rhetorical or symbolic, institutions cannot afford to assume benign intent. The cost of underestimating risk is too high. That is why responses are measured but firm. This moment also illustrates how quickly situations can escalate once institutional patience is exhausted. Courts tolerate delay and aggressive advocacy up to a point. When that point is reached, escalation occurs not through spectacle, but through procedure. A referral replaces warnings. Preparedness replaces assumption. Public reaction has been predictably polarized. Supporters frame these developments as persecution and overreach. Critics frame them as overdue accountability. Institutions, however, are focused on something narrower, preventing instability while constitutional mechanisms do their work. As this unfolds, clarity matters. Sensational claims obscure understanding. Precision reveals it. What we know is that rhetoric has intensified, a judge has escalated formally, and security agencies have adjusted posture to prevent unrest. Those facts alone explain why this moment is being treated differently from previous episodes. In the next part, we will examine in detail what a judicial referral to Congress actually triggers procedurally, what Congress can and cannot do in response, and why security agencies respond to rhetoric even when no formal orders for violence exist. For now, the reality is this. Institutions are responding in real time to a volatile mix of language, legal escalation, and public reaction. The goal is containment, not confrontation. And how the next steps unfold will depend on whether escalation continues or restraint prevails. To understand why this moment is being treated with such gravity, it's important to look closely at what a judicial referral to Congress actually represents in practical terms. This is not a symbolic gesture, and it is not a political statement. It is a procedural acknowledgement by the court that its authority standing alone may no longer be sufficient to address the conduct before it. Federal judges have powerful tools. They can issue orders, impose sanctions, hold parties in contempt, and in extreme cases, order detention. When a judge chooses instead to refer findings to Congress, it signals that the issue has crossed from routine adjudication into constitutional oversight. In essence, the court is saying that the problem is no longer just legal, but institutional. That distinction matters because Congress operates under a different set of responsibilities. Courts resolve disputes. Congress determines accountability for public officials, particularly when conduct threatens the constitutional order itself. A referral does not compel Congress to act, but it formally places the matter within its jurisdiction and removes any plausible claim that lawmakers were unaware or uninformed. This is where the situation becomes particularly sensitive. Congress is a political body, but it is also a constitutional one. Once a referral is received, lawmakers must decide whether to initiate inquiries, request evidence, or begin formal proceedings. Choosing not to act is itself a decision, one that carries long-term implications for precedent and institutional authority. At the same time Congress is weighing its options, security agencies are making their own assessments. Their role is not to judge legality or constitutionality, but to evaluate risk. They examine whether rhetoric could mobilize groups, whether there are signs of coordination, and whether public gatherings could escalate into disorder. This process is largely invisible to the public, but its outcomes sometimes are not. Heightened readiness does not mean inevitability. It means uncertainty. Officials plan for worst-case scenarios not because they expect them, but because failing to plan would be irresponsible. After January 6th, the threshold for concern changed. What once might have been dismissed as heated political speech is now analyzed through the lens of demonstrated consequences. This is why Trump's recent statements are being scrutinized so closely. Context matters. Past behavior matters. Audience reaction matters. When rhetoric references force or resistance during an act of legal escalation, it triggers alarms regardless of intent. That does not mean guilt is presumed. It means risk is acknowledged. From a legal standpoint, the interaction between rhetoric and judicial process is especially delicate. Courts expect litigants to respect the authority of the system even while challenging it vigorously. When public statements appear to undermine that authority or threaten its functioning, judges take notice. That is often when escalation occurs. Trump's legal team now faces a problem that cannot be solved with motions alone. They must contend with how statements made outside the courtroom affect proceedings inside it. Judges are not isolated from reality. They are aware of the broader environment in which their orders are received and enforced. There is also the question of obstruction. While protected speech is broad, it is not unlimited. Speech that intimidates witnesses, pressures officials, or attempts to derail lawful process can cross legal lines. Determining whether that has happened is complex and fact-specific, but the risk of inquiry increases as rhetoric intensifies. This places Trump's lawyers in a defensive posture on multiple fronts. They must argue legal merits while simultaneously managing reputational and institutional fallout. That is a difficult position, especially when statements are issued directly by the client and not filtered through counsel. Congress, meanwhile, is navigating its own dilemma. Acting too aggressively risks accusations of partisanship. Acting too cautiously risks accusations of abdication. The referral forces lawmakers to confront that balance openly. It removes the option of quiet avoidance. Behind the scenes, conversations are already happening. Lawmakers are consulting constitutional scholars, reviewing precedents, and gauging public response. None of this happens overnight. Institutional processes move deliberately, but once initiated, they are difficult to reverse. Security agencies must operate in parallel. Their task is not to influence political outcomes, but to ensure that whatever outcome emerges does not lead to violence or instability. That is why visibility matters. Deterrence is often achieved simply by making preparedness visible. Public misunderstanding is one of the greatest risks in moments like this. Claims of martial law, coups, or imminent civil war spread rapidly online, but they distort reality. There is a difference between precaution and emergency. There is a difference between escalation and collapse. At this moment, the system is under stress, but it is functioning. Courts are issuing orders, Congress is receiving referrals, security agencies are preparing responsibly, civil authority remains intact, elections, governance, and daily life continue. What makes this moment consequential is not that institutions are failing, but that they are being tested. The strength of a system is revealed not when it operates smoothly, but when it absorbs shock without breaking. Trump's rhetoric has increased the temperature. The judge's referral has raised the stakes. Security measures reflect caution rather than panic. Together, they form a picture of a system attempting to manage risk before it spirals. In the final part, we will look at what realistic next steps could unfold from here, how this situation could de-escalate or intensify depending on choices made, and why restraint at this stage may matter more than any single legal ruling. For now, what is clear is that this is no longer just a legal dispute or a political argument. It is a moment where language, law, and security intersect, and where the decisions made in the coming days will shape how this chapter is remembered. In the next part, we will examine in detail what a judicial referral to Congress actually triggers procedurally, what Congress can and cannot do in response, and why security agencies respond to rhetoric even when no formal orders for violence exist. For now, the reality is this: institutions are responding in real time to a volatile mix of language, legal escalation, and public reaction. The goal is containment, not confrontation, and how the next steps unfold will depend on whether escalation continues or restraint prevails. As this situation moves forward, the most important variable is no longer what has already happened, but how institutions choose to respond next. Moments like this rarely turn on a single decision. They turn on sequences, on whether escalation is met with escalation or whether restraint reasserts itself before lines are crossed. From Congress's perspective, the judicial referral creates a narrowing window. Lawmakers cannot pretend the issue does not exist. They must decide whether to request additional information, open formal inquiries, or decline to act and accept the consequences of that choice. Each path carries political risk, but more importantly, each path sets precedent. How Congress responds will shape expectations for future cases where courts signal that judicial remedies have reached their limits. For the courts, the next phase will be about maintaining authority without inflaming tensions. Judges are acutely aware that their legitimacy depends on public confidence. They must enforce orders firmly while avoiding language or actions that could be interpreted as partisan or provocative. That balance is difficult, but it is precisely what judicial independence demands in moments of stress. Security agencies face an equally delicate task. Their responsibility is not to anticipate political outcomes, but to prevent disorder regardless of outcome. That means planning for protests, counter-protests, and misinformation-driven mobilization. It also means adjusting posture dynamically, scaling presence up or down as risk assessments change. Visibility is used strategically, not as a signal of fear, but as a signal of preparedness. What happens next will also depend heavily on rhetoric. Language has power. De-escalatory language can reduce risk. Inflammatory language can amplify it. This is not a matter of political correctness, but of cause and effect. In an environment already charged with suspicion and polarization, words can accelerate events faster than institutions can respond. Trump's choices in this regard will matter. Continued escalation increases scrutiny and hardens institutional responses. Restraint, even if temporary, can slow momentum and create space for procedural resolution. Legal strategy and public messaging are now inseparable, whether lawyers want them to be or not. Public reaction will also play a role. Institutions are not driven by polls, but they are influenced by legitimacy. Peaceful engagement strengthens constitutional processes. Threats, intimidation, and calls for force weaken them. How supporters and opponents respond in the coming days will affect how confidently institutions can proceed. It is worth emphasizing again what this moment is not. It is not a declaration of civil war. It is not a suspension of democracy. It is not the collapse of constitutional order. Those narratives thrive online because they simplify complexity into spectacle. Reality is slower, more procedural, and more constrained. What this moment represents is stress testing. The system is being challenged by rhetoric, legal escalation, and public distrust simultaneously. The response so far suggests an effort to manage that stress through established mechanisms rather than extraordinary ones. Judicial referrals, congressional deliberation, and security preparedness are not signs of breakdown. They are signs of engagement. They indicate that institutions are taking potential threats seriously without abandoning process. History shows that democracies are most vulnerable not when institutions act, but when they fail to act. Silence, avoidance, and denial create vacuums that extremism fills. Action, when measured and lawful, preserves space for resolution. The coming days will likely bring more statements, more analysis, and more speculation. Some voices will insist catastrophe is inevitable. Others will insist nothing matters. Both extremes miss the reality. What matters is whether institutions continue to respond proportionally and whether individuals choose restraint over provocation. The reason this moment feels different is not because outcomes are predetermined, but because consequences are now visible. Words are being weighed. Actions are being anticipated. Authority is being asserted carefully rather than assumed. That is how systems endure pressure. Not by dramatic gestures, but by incremental decisions that reinforce boundaries. Courts signal limits. Legislatures debate responsibility. Security agencies prepare without overreach. Whether this chapter ends in de-escalation or further confrontation will depend less on any single ruling and more on collective behavior. Institutions can only do so much. Ultimately, stability requires a shared commitment to process over force. For now, the system is holding, not because it is unbreakable, but because it is being actively maintained. The next steps will reveal whether that maintenance continues to be enough. We will continue to follow this closely, focusing on verified actions, official records, and institutional responses rather than rumor or amplification. In moments like this, clarity matters more than volume, and understanding matters more than outrage. For now, what is clear is that this is no longer just a legal dispute or a political argument. It is a moment where language, law, and security intersect, and where the decisions made in the coming days will shape how this chapter is remembered. In the next part, we will examine in detail what a judicial referral to Congress actually triggers procedurally, what Congress can and cannot do in response, and why security agencies respond to rhetoric even when no formal orders for violence exist. For now, the reality is this: institutions are responding in real time to a volatile mix of language, legal escalation, and public reaction. The goal is containment, not confrontation, and how the next steps unfold will depend on whether escalation continues or restraint prevails.